Auto Quickie. In the Quickie on gay cakes, we covered the Masterpiece Cake Shop. In gay websites, we covered 303 Creative. And last week, we covered Boy Scouts of America, all of which said that it wasn't a civil rights violation to refuse to be associated with a message, not just a group. Let's add to that Hurley v. Irish American Gay, Lesbian, and Bisexual Group of Boston. The South Boston Allied War Veterans Council applied for a parade permit in 1992, and they refused a float from the Irish American Gay Rights Group. Fast forward through a bunch of lower court cases, and in 1995, the Supreme Court upheld the right of the council to exclude members expressing a message they didn't want to convey. David Souter delivered the unanimous opinion. The council is a speaker in its own right. A private speaker does not forfeit constitutional protection simply by combining multifarious voices or by failing to edit their themes to isolate an exact message as the exclusive subject matter of the speech. Disapproval of a private speaker's statement does not legitimize use of the Commonwealth's power to compel the speaker to alter the message by including one more acceptable to others. And let's throw in one more while we're hot. Coral Ridge Ministries v. Amazon. Amazon Smile is a method Amazon has of sending part of the take to various charities, but they didn't want Coral Ridge Ministries to be one of them. Coral Ridge Ministries is that whack job religious group founded by young earth creationist nutcase D. James Kennedy. So you sympathize with Amazon. Coral Ridge has a First Amendment right to exercise their screwball hate religion, but Amazon doesn't have to support it. The 11th Circuit Court of Appeals ruled. The parties do not dispute that donating money qualifies as expressive conduct. Indeed, it is bedrock principle that no person in this country may be compelled to subsidize speech by a third party that he or she does not wish to support. Based on Hurley, quote, Hurley is analogous to this case in that Coral Ridge's proposed interpretation of Title II would violate the First Amendment. In the same way that the Council's choice of parade units was expressive conduct, so too is Amazon's choice of what charities are eligible to receive donations through Amazon Smile. Applying Title II in the way Coral Ridge proposes would modify the content of Amazon's expression and thus modify Amazon's speech itself by forcing it to donate to an organization it does not wish to promote. This we cannot do. The Supreme Court denied cert, so the ruling stands. Like the parade, like Boy Scouts, like Masterpiece, and like 303 Creative, the message went beyond merely who you were doing business with and went to the message you were working with them to convey. There's a difference between baking a cake for a gay couple and making a cake with a gay wedding message on it, making a website for a gay couple and making a website celebrating gay marriage, a gay scoutmaster and a scoutmaster who's an activist, holding a parade and using the parade to express a message you disagree with, or between being charitable and promoting a charity you find odious. That is the fundamental difference between discrimination and expressive association.